It is a couple of minutes past the hour, so let's begin. Welcome to this seminar, webinar on Pakistan International Airline Corporation and Times Travel, co-hosted by the Chambers of Philip Shepherd, QC, 3 Hare Court and Hausfeld. I'm Ned Beale, a partner specialising in litigation and arbitration in Hausfeld's London office. The purpose of this seminar is to give you a snapshot of the Supreme Court's decision, which was the first time it's considered the doctrine of economic duress and was handed down on the 18th of August. I'm joined by 2 panellists, Philip Shepherd and Thomas Rowe. They couldn't really be better qualified to talk about this decision. Philip was a practice in 24-year-old buildings for many years before setting up his own chambers earlier this year. He's no stranger to Supreme Court, having persuaded the court in Patel and Mirza to adopt a multifactorial approach to illegality. And in Pakistan and Times Travel, he acted for Times Travel at first instance at the Court of Appeal and in the Supreme Court. Meanwhile, Tom Rowe from 3 Hare Court is also a regular participant before the Supreme Court and the Judicial Committee of the Privy Council. I instructed him as lead counsel on behalf of the All-Party Parliamentary Group on Fair Business Banking, who intervened in the Supreme Court hearing of Pakistan International Airlines. So this webinar will have 3 parts. First of all, Philip will talk us through the background to judgment and the judgment itself. Secondly, Tom will discuss where this now leaves economic duress and, I suppose, related claims a bit more broadly. And thirdly, we will have a discussion and questions. And I myself have a couple of questions to put to Philip and Tom, but I am very welcome to receive questions from those listening in, and will prioritise those over my own. So if you have a question, feel free either to put it in the chat or to raise your virtual hand and we can let you in and you can ask it directly in person. So I really would invite you to do that, and you're welcome to do it at the end of the 3rd part. But if you have something burning to ask, please don't feel like you need to wait. Final bit of housekeeping is that this is being recorded, and we will do our best to finish within an hour, if not a little bit sooner. So with that, over to Philip.
Everybody, I have been allotted 15 minutes to say what really demands a day or more to examine properly. But my aim is to give you enough of the key points emerging from the Times Travel case to recognise economic duress when you see it. At its simplest, duress in its economic appearance is entering into a contract because, in the words of The Godfather, that, by the way, is the best film ever, I'm sure you'll agree, you've been made an offer you can't refuse, and not in a good way. So what are now the ingredients of economic duress? And the other question is, can economic duress arise where lawful acts or threats are made by one party in support of a demand which that party believes it's entitled to make? But I think that before we answer that question, one has to look at the theoretical underpinnings of duress, because in my view, it unlocks an awful lot of meaning and explanation as to why the doctrine exists at all. Now, it may seem obvious, but it's so often forgotten the reason why the law enforces contracts is that it assumes that the parties have freely entered into a bargain with one another. The so-called freedom of contract theory that in the 19th century was read in tooth and claw, in the sense that there was almost complete freedom of contract. As we know, freedom of contract's been gradually eroded by the common law and by equity, and of course by statute. So how should the law react when it becomes clear that the only reason the contract was entered into was pressure by the other party? A contract that would never have been entered into on those terms, but for that pressure. The trouble is that many contracts are entered into under pressure. And in even more cases, the bargaining power of the parties is unequal. Everyday examples of that are all around us. Banks and their customers, large organizations that dominate the economic marketplace. The examples can be multiplied, and inequality of bargaining power is simply a fact of life. But surely every right-minded person would agree that outright coercion has no place in the law of contract. Or to use the buzzword found in all the cases, it has no place where pressure is used that is, and here's the key word, illegitimate. But what does illegitimate mean? So does it all come down to this simple question? What qualifies as illegitimate? What qualifies as coercion and what doesn't? What will the law classify as illegitimate? Where is the line to be drawn between the rough and tumble of commercial bargaining and pressure that is so repugnant to a court that a party will be relieved of the obligations that it has otherwise contractually undertaken? Remember that economic duress is a doctrine that is designed to relieve a party of contractual obligations. It renders a contract voidable, not void. So someone has to do something about avoiding the contract. The answer advanced by the respondent in Times Travel was simple. If the threat or pressure is to do something that in itself is lawful, in this case to terminate the agency contract between PIA and Times Travel by giving 1 month's notice to terminate the agency, which it was perfectly entitled to do. The contract said in terms that the carrier can give the agent 1 month's notice, no reasons required. It had the absolute right to do that. Now, the fact that that would have put Times Travel out of business altogether was just a consequence of what had been agreed. It would have put Times Travel out of business altogether because it was effectively a sole agent in the Birmingham area for PIA. So their answer was, we're entitled to terminate the contract. End of story. We're doing something lawful. Now, put another way, if the pressure relied on was to do something they were legally entitled to do, Their answer was, with one caveat, that unless the pressure amounts to the crime of blackmail, then that would be the end of the analysis. No need to go any further. They did add the caveat that where the pressure amounted to the crime of blackmail, so the demander genuinely believing that it had reasonable grounds for making the demand and that it was proper to reinforce it with particular threats. Only where that was not the case, their contention was that the fact that the act used in order to impose their demand was lawful should be the end of the analysis. And the test, of course, in blackmail is subjective. There's no requirement that the demander must have reasonable grounds for his belief in his own case. How convenient and self-serving, I hear you all say, or at least I hope I do. Happily, the Supreme Court declined to go down that particular rabbit hole. So they rejected the notion that all you had to do was to demonstrate that what you were doing in exerting the pressure was use lawful acts. So what did the majority of the Supreme Court decide, and why? I say the majority because Lord Burrows, although he agreed that my appeal should be dismissed, did so for a different reason. So how did the Supreme Court steer a path between freedom of contract and contracts that can be set aside because they were procured by the use of pressure that the law regards as illegitimate? I'm going to give you a series of key points, the takeaway points. The first key point is that Supreme Court all accepted that lawful act duress, in other words, using a lawful act to inflict pressure on another party, does exist in English common law, meaning that even where the threat is to do something lawful in itself, that doesn't automatically disqualify that threat from the outset. Why so? Well, essentially for three reasons. Three reasons for the existence of lawful act duress. First, the case law refers to illegitimate rather than unlawful acts. So cases such as Universe Tank Ships and ITF, and pretty much all the following cases, have deliberately avoided using other labels because the class of conduct that qualifies as illegitimate is not closed, and there's no reason in policy why it should be. So first justification is all the cases have said illegitimate. They haven't drawn the simple distinction between lawful and unlawful. The second justification is that the crime of blackmail includes threats of lawful action. And it would create a dissonance in the law if lawful threats were enough for the commission of a serious criminal offence, but they're not enough for setting aside a contract. You can immediately see that that would be a very odd outcome given the same facts, that the civil law provided no remedy, but the criminal law could put you away for 14 years. Thirdly, the Supreme Court recognised that there have been a series of cases in which it's been accepted that threats of lawful action entitle a party to rescind a contract. And they didn't have to follow any of those cases, but they decided that there was sufficient movement in one direction to justify upholding lawful act duress as a tort. So key point number one is lawful act duress exists. The second key point follows from the first, and that is, what are the elements of duress? Well, you may conclude, having heard what the three elements of duress are, which doubtless you already know, that it doesn't actually tell you very much. Because first you have to have a threat or pressure exerted by the defendant, which is illegitimate. But I hear you say, what does illegitimate mean? Second, it is that the illegitimate threat caused the claimant to enter into a contract. So you have to establish causation. And thirdly, economic duress also has a third element. The claimant must have had no reasonable alternative to giving in to the threat or pressure. Now, the majority declined to go down the route of bad faith as introducing an unwelcome sea change in English commercial law. As many of you will know, Lord Legate has been waving, and others, it's fair to say, have been waving the flag of bad faith in a number of cases, but in this instance, the Supreme Court decided that bad faith was not to be an element of lawful act duress. Why so? Because it introduces an awful lot of uncertainty into our commercial law. They preferred to keep within notions of illegitimate conduct that was equated with behavior that was, here's another expression that you may find, or that you may think is like nailing jelly to the wall, unconscionable or highly reprehensible. They observed that economic duress cases fall into two categories, which I'll come to in a moment. But you may think that using notions as widely drawn as unconscionable behavior and expressions like highly reprehensible doesn't provide you with much of a basis for defining illegitimate. It's just using a different word. But at least expressions or words like unconscionable are well known to equity lawyers. The third key point is at the core of the case. What counts as illegitimate pressure or threats? Well, perhaps it's not surprising that the Supreme Court didn't offer a definitive working formula. What it did was to point to two classes of case in which the laws recognized lawful act economic duress, and then point out that they derived support from equitable concepts. Those two classes of case are quite confined. The first is where a defendant uses his knowledge of criminal activity by the claimant or a member of his family to obtain a personal benefit from the claimant by threatening to report the crime or initiate a prosecution unless the party threatened agrees to enter into an agreement. Put bluntly, it's the sort of agreement that goes, pay me X or I will shop you or a family member to the authorities for something that you know and I know you have done wrong and that amounts to a crime. There's a series of cases where economic duress has been held to entitle that party to avoid the contract. A very, very limited class of case, a fairly unusual situation. The second class of case is what I call the over-the-barrel cases, a rather more common series of facts that have allowed the courts to apply the doctrine of economic duress. So where the defendant, having exposed himself to a civil claim by the claimant, for example, for damages for breach of contract, deliberately maneuvers the claimant into a position of vulnerability by means that the law regards as illegitimate and forces the claimant to waive his claim. So in the shipping context, the owner fails to present the promised vessel for loading, promises that he will provide an alternative, and then at the very last minute says, yes, I'll do that, but only if you agree to sign just here to waive all your claims against me. In both categories of case, the defendants behaved pretty badly, and the courts have treated this as amounting to illegitimate pressure. In other words, maneuvering the other party into a corner or putting them in a position where they have no choice but to agree to enter into the agreement at the time that they do so. The expression over a barrel was actually Lord Savile's expression in a case called Borelli and Tim. He drew attention to the influence of equity on lawful act economic duress, and Lord Hodge does so too. So the place of lawful act economic duress needs to be seen against the backdrop of remedies that equity already provides, and so mere inequality of bargaining power isn't sufficient. What constitutes an illegitimate threat or pressure is closely aligned to concepts like, as I've said, unconscionability. Yet that is a notoriously difficult concept to pin down. But don't despair, because the Supreme Court says that this does not mean that judges are the arbiters of what is morally and socially acceptable. Well, if they aren't, I wonder who is. Rather, equity, says Lord Hodge, has identified specific contexts which call for judicial intervention to protect the weaker party. Well, that still puts the judges in the driving seat, in my view. In the absence of a doctrine of inequality of bargaining power, and we have no such doctrine, or a principle of good faith in contracting, the majority said that it's going to be rare that a court will find lawful act economic duress, particularly in the context of commercial negotiation. And he said that other jurisdictions were similarly cautious in declaring commercial behavior illegitimate. Self-interest is the touchstone of arm's length contractual negotiation. So just to finish up, you may well ask, given the facts of time's travel, how did I lose? Well, Ned was good enough not to mention the fact that I lost, but I did lose. Most of you will be very familiar with the facts. Large number of agents are demanding arrears of commission. Times Travel is persuaded not to join the litigating agents by promises that they would be paid. This is superseded by service of a notice terminating their agency agreement on 1 month's notice. During the period of notice, the ticket allocation is cut from 300 to 60, thereby choking their cash flow. Times Travel are heard to make howls of protest, but the trial judge isn't able to find that PIA behaved in bad faith. Unsurprisingly, although the trial judge found that Times Travel had no alternative but to sign the contract that included a term giving up what turned out to be £1.2 million worth of commission, and although the trial judge held that that amounted to economic duress, both the Court of Appeal and the Supreme Court held that that was not a circumstance in which it was so far removed from the rough and tumble of commercial negotiation as to amount to illegitimate behaviour. What the Supreme Court did accept, though, was that one didn't focus on the nature and justification of the demand. One looked at the nature, I'm so sorry. The Supreme Court did accept the appropriateness of focusing on the nature and justification of the demand rather than the legality of the threat. So that much is established. Very nearly finally, the fourth point is a summary of what the Supreme Court rejected. And as I've already touched on, perhaps of the greatest importance is the rejection of the use of a wide principle of good faith and fair dealing. Good faith, as you know, is an important concept in many civil law jurisdictions, but rightly, in my view, it was rejected because it's a notoriously slippery concept and it would reduce the great attraction of English commercial law, namely certainty of outcome. But of course, parties are free to include good faith obligations in their contracts expressly, but when they do so, they have the opportunity to define its meaning. Also rejected was what I suggested was ought to be the approach, which is a sort of multifactorial approach, which is more akin to, well, you don't define it. It's like an elephant. It's easier to recognize than to define. Now, Lord Burroughs dissented. I probably don't have time to go into Lord Burroughs' dissent, but and to some extent it doesn't matter. He was focusing on the demand for a waiver by the threatened party of a claim against the threatening party, and held that if a demand was unjustified and the demanding party knew that it was unjustified, then that would amount to economic duress. And you'll read in the judgment that there's a good old ding-dong going on between the majority and Lord Hodge, who spends a lot of time in knocking down Lord Burroughs' arguments. Now, in the end, what the court came to was that the conclusion that hard-nosed bargaining, even hard-nosed exercises of monopoly powers, should not bring conduct into the realm of illegitimate conduct. But you may think that just calling it hard-nosed exercise of monopoly power is simply a change of label. And that ought to have swayed the Supreme Court, but it didn't. So that's it, ladies and gentlemen. The basis of economic duress it is now, in my view, somewhat limited to circumstances that I know Tom is going to deal with.
Thank you very much, Philip. We have one very good question, which overlaps with one of my own, but let's hear from Tom first and then move to that.
Good, thank you. Well, thank you, Philip, for those observations on the case and on your view as to the outcome. Perhaps unsurprisingly, when one acts for one party, after a bit, it becomes apparent which way the case ought to go. And I sympathise with your final point that perhaps it should have gone the other way, but or at any rate with your inclination to feel that way. It seems to me the case raises actually a fairly fundamental point about where the boundaries lie in terms of the conduct that is permitted in contracting between parties in commercial life in general terms. If some of you will recall a few years ago, the late Lord Bingham wrote a book called The Rule of Law, which had a certain acclaim and is still recommended, I think, to law students and others to read. One of the chapters of that book is called Law and Discretion. And he makes the point, perhaps it's an obvious point, but he makes it very well and gives some examples of its operation in practice. He makes the point that for the rule of law to be something meaningful and for us to live in a society which has the rule of law, it must be apparent what you can do and what you can't do. Apparent, that is to say, in advance, and not just once you've done it and a judge comes along and says, or an official comes along and says, well, I'm afraid you couldn't do that. The idea that standards of conduct are laid down in advance is an important element of the rule of law. Otherwise, we're all vulnerable to the caprice of whoever it is who is judging our conduct. And in that context, the question arises, well, if you are entering into a commercial bargain with somebody with whom you have a pre-existing relationship, because let's say you owe them some money, what is it that you can and what is it that you can't do? And that's, I think, the fundamental difficulty with the law of lawful act duress. It's very easy to say, of course, if I sign a contract agreeing that suppose one of the good members of this audience owes me some money for some work I did, and you come around one day with a gun and say, well, I'd like you to sign this waiver to say that you won't actually demand those fees. I think it's pretty clear to everybody that whether I sign or not doesn't make any difference, because I can always avoid that contract as having been procured by unlawful means. But what one can do within the boundaries of the law is obviously quite varied, and whether something which is within the boundaries of the law is nevertheless something which in some way means that my bargain is not treated as really my bargain is, I think, always a difficult question. And if we recall that the facts of this case, Times Travel, and Philip has already mentioned this, Times Travel was a travel agent whose sole business was selling tickets to people who wanted to fly to Pakistan. And the Pakistan International Airlines was the only airline that did fly direct to Pakistan. And Times Travel's contract with Pakistan Airlines allowed the airline to terminate on a month's notice. So you might think that it's a classic case of, I think you'd be right to think, it's a classic case of a person in a very weak bargaining position. And the airline essentially threatens to exercise its right to terminate unless Times Travel agrees to write off a lot of unpaid commission, which had accrued over a period of time. Now, the point that was made by Lord Hodge in the majority judgment is this, that it's all essentially, it's all very well to say, well, here was Times Travel being required to write off its legal entitlement. But he makes the point that, of course, the airline could simply have said, well, look, we don't want to trade with you anymore. That would have been permitted under the contract. We allow parties to decide who they do and don't want to contract with, subject to certain limited exceptions in the public interest. You can't obviously say that you won't contract with people of one sex or another, or you can't say I won't contract with people of one race or another, because for public policy reasons, that's regarded as unacceptable. But generally, you can decide who you want to contract with. So it would have been perfectly possible for the airline, for a good reason or for no reason or for a bad reason, to say it didn't want to contract with Times Travel anymore. And when Times Travel came on bended knee saying, are you really sure? Because that will drive us out of business, they could have said, okay, well, how about you agree to pay us £1.2 million as a premium for carrying on? As far as I can see, all of the judges thought that would be acceptable, might be questionable in moral terms, but it would be acceptable in legal terms. What made the difference for Lord Burroughs was that here was an existing legal relationship. And he said that if the airline had not believed in good faith that it had the defense to the claim, then it would have been acting in bad faith in doing what it did, and the contract would have been capable of being unwrapped. Well, for my part, I'm a bit skeptical about Lord Burroughs's take on all of this. It seems to me that what the Supreme Court did in the present case is probably right, because they recognize the extreme difficulty of trying to carve out situations where someone can get out of a contract because the pressure that they were put under to sign it didn't involve anything unlawful happening. For the reasons I mentioned at the beginning of these short observations, that's difficult because it trespasses into that area of law versus discretion. Why shouldn't somebody be able to do something which is lawful, even if we might disapprove of it? Seems to me this is really an instance of a hard case, and the Supreme Court, though it was very beguilingly tempted by Philip to do so, didn't in the end what it seems to me, at any rate, might have made for bad law. So where does it leave the law? Well, as Philip says, the doctrine of lawful act duress has not been killed off completely. One of the submissions in the case had been from some of the parties and interveners that it should simply be killed off, and the court should set the doctrine aside altogether and say, essentially, if you want to get out of a contract on the ground of duress, then you have to show that what was done to you to persuade you to sign the contract was actually illegal, and anything less will not suffice. They didn't quite go that far. Understandably, judges, of course, rarely want to rule anything out because they never quite know what the facts of the next case that comes onto the books will be. But they've come pretty close to it. What the majority have said, as Philip indicated, is that there are just two circumstances in the case law where a lawful act duress has operated, as Philip has said. One where you use knowledge of criminal activity on the part of the other party and a threat to reveal it as a way of getting one over on your contracting counterparty, and the other is where you deliberately maneuver somebody into a position of vulnerability where you've already exposed yourself to a civil claim. And Philip gave you the example of the shipping case, which is a reference to one of the cases that the Supreme Court referred to. So those are the existing categories, and I think the Supreme Court has gone as far as it could go in saying really that those are the two categories that exist for lawful act duress. But they have left open, of course, in theory, the possibility there might be others. They haven't said those are the only categories of case where it'll ever apply, but they made pretty clear that they're not keen on expanding it beyond that. In a sense, it's a rather conservative with a small c decision, which is perhaps what one begins to expect from Lord Reed's court, which I think has shown itself to be not a court which is keen on expanding the boundaries of the law and breaking new ground legally. As Philip said, and it's an interesting aspect of the case, there is a pretty vigorous debate between the majority and Lord Burrows. Indeed, it's quite obvious from the way it's all drafted that Lord Burrows was sent off to draft what they thought would be the unanimous decision of the court. You can tell that because he sets out all of the facts as if he were writing the main judgment of the court, and goes through a lot of established propositions about the law of duress, and then gets to the crucial bit about whether, on the facts of this case, if Pakistan International Airlines had not believed in the merits of their defense, whether in those circumstances their insistence on having the claims waived as a condition of doing any more business with Times Travel would have been something that would have vitiated the contract. He says, actually, yes, it would have vitiated the contract, because he carves out a special area of the law, in his view, whereby if you're in a situation where you owe somebody some money, you don't believe you have any defense to it, and you then use pressure, as he puts it, in bad faith to get a waiver of that, then in those circumstances, he foresees there could be the operation of the doctrine of lawful act duress, so that the waiver could be overridden. The majority is not having any of that, and it says that doesn't work. And for what it's worth, my view, I think, is the majority are probably right about that. I'm not sure that the interveners that Ned and I were acting for would necessarily agree with that. They were the all-party parliamentary group on fair business banking, and they were hoping for, I think, a fairly expansive view of the law of lawful act duress, because they are interested in the difficulties that many small and medium-sized enterprises have with their banks. The classic situation is the bank threatening to exercise its strict contractual rights in order to make you write off claims that you might have against the bank in a situation of overwhelming pressure. So they were quite keen, I think, on an expansion. But as I say, personally, I think there's a lot of force in what Lord Hodge says in the majority judgment. He specifically points out that a demand for a waiver, even if Pakistan International Airlines had known it had no right to demand such a waiver, is no difference in principle from somebody demanding a premium up front as a price of contracting. And as I indicated what the facts of this case were earlier, you can change the facts only a little, I think, to see how things might have looked different. Suppose that there had been a sort of travel agent's annual gala dinner, and the Times travel representative had turned up and made a speech in which he'd been rude about Pakistan International Airlines. And it had come to their notice, and they'd say, we don't want to deal with Times travel anymore. And they'd gone on bended knee to them and said, look, sorry, we're sorry about that. And Pakistan International Airlines had said, okay, but you need to write off those existing claims you got against us. Would anybody have said that was unlawful? Would they have been able to accept those terms, carry on trading, and then a few years later say that we want the unpaid money? Query. So I think it's tricky, and I think what Lord Burrows has sought to do, it comes a little bit close to the sort of legislative acts that the common law doesn't tend to do. The common law generally, as we know, talks in generalities, general principles. It says that if you want a contract, there has to be consideration, which has to consist of something that passes from the party paying consideration. It says that you have to look out not to do things that might foreseeably damage your neighbor. It doesn't tend to say that in a specific situation, such as where there is an existing claim against you and you are then seeking to persuade the other party to waive that claim, you must behave in a certain way. And I think what Lord Burrows was trying to do was to formulate a rather specific exception for the facts of this case, or a case like this, but the Supreme Court was having none of it. So that's where. So as regards the law of lawful act duress, then in this jurisdiction, the answer is that it's pretty limited in scope. And if you are seeking to get out of a contract that was entered into in unfavorable circumstances, you are probably not going to get very much out of this judgment, though, as I say, they have not said never. They have not closed all the categories down. So who knows whether somebody with sufficient ingenuity and I suspect facts on their side, which really appeal to a court, might not yet be able to succeed in getting out of a contract on those terms. But it doesn't look very promising. And the main takeaway that I would say from this judgment is that one probably needs to look either at some way of finding that what the party who caused your client, if you're acting for the person trying to get out of the contract, what the party that caused your client to waive did was unlawful. Try and find some way of arguing that what that party did was unlawful. Alternatively, you're probably driven back, if you can get there, on the equitable doctrines: undue influence, unconscionable bargain. But those are very high thresholds to get over. So this is a thoroughly laissez-faire, free trading, devil take the hindmost sort of judgment. I'm afraid, I'm afraid, depends who your clients are. For some clients, that might be terrific. For others, it might not be. But that's where, at the moment, it seems to me, the law is left. What will happen to the law around the world, I don't know. Different countries, different common law jurisdictions have differed to some extent about this. But I'm sure this judgment will be studied very closely in other common law jurisdictions. All right, Ned, that's for the moment, I think, what I want to say. But I expect there might be a question or two.
Thank you very much. And just to add, from my perspective, having been acting for the All-Party Parliamentary Group on Fair Business Banking, I mean, it was disappointing because that group had received a lot of evidence and case studies from constituents, from borrowers who had really been placed under intolerable pressure, and had certainly entered into waivers that they should not have found themselves in that position. But I suppose you can say from that point of view, there is a regulatory framework. And if, for example, you brought commercial lending or commercial lending to SMEs within the FSMA regulatory perimeter, that would be a regulatory solution which would be an alternative to extending this doctrine. Looking at it more broadly, let's take this question, which is a very good one. We've talked about lawful act duress. What about unlawful act duress? And in particular, the proceedings between Debenture Law Trust Corporation in Ukraine, where the state of Ukraine is saying, amongst other things, that it was compelled to enter into bond contracts with its lenders as a result of unlawful acts by the Russian Federation.
Well, Shall I go first on that one? I mean, the interrelationship between that claim and the present claim is that in that case, which, Ned, as you said, was a dispute between the Russian Federation, in other words, Russia, and Ukraine, the Court of Appeal said that it was arguable that Ukraine might be able to escape from certain contractual obligations that it owed to Russia, on the ground that the circumstances in which those obligations had been procured were morally and socially unacceptable. And what was said there was that there was alleged duress by Russia against Ukraine in circumstances which anybody who follows the news will be familiar with in broad terms. And it was said, well, allegedly that was a breach of international law, the way Russia behaved, and that was the relevant threat. And the reason, what happened in procedural terms was that claim, which was on its way up to the Supreme Court, was stayed pending the argument in our claim in the Times Travel case, because similar issues arose. Also, Ukraine and Russia actually intervened in the case, seeking to persuade the Supreme Court of their competing visions of the doctrine of lawful act duress. Russia saying, not surprisingly, there's no such thing. Provided you don't actually break domestic English law in what you do, then anything goes. So it doesn't matter whether we behave badly towards Ukraine or not. We didn't break the law, so that's that. And Ukraine contending for something rather more along the lines of what Philip was contending for on behalf of Times Travel. Where does it leave that claim? Well, I suppose the answer is that they're unlikely. They're very. I mean, in theory, it's a different panel of judges who are determining the Ukraine and Russia case, which will presumably, I assume, be relisted for further argument in the light of this judgment. And in theory, it's a different panel. So I suppose a different panel could take a different view of the law from the Supreme Court in our case, from this panel of the Supreme Court in our case. But that seems very unlikely in principle, particularly in circumstances where Russia and Ukraine were allowed to intervene to make their submissions. So they'll be stuck, both parties, with the law as declared in this judgment that we're talking about today. Where exactly that leaves the claim, I think one will need to go back and look in more detail than we've got time to do now, or certainly I've had the opportunity to do now in somebody else's case, at exactly what the facts were. But they would need to fit in, if the doctrine is to have any application, one would think, into that fairly limited category of two things that are referred to by the majority in their judgment. And the court will also need, I suppose, to look at the question of whether actually this might be regarded as, the Ukraine case might be regarded as unlawful act duress, which depends in turn on how you regard international law, and whether you say international law in this context ought to be regarded as being part of the law of the land, which is a whole different subject, which would no doubt merit a seminar or two of its own.
Yeah. Can I just butt in here? It doesn't seem to be entirely a binary choice between lawful act and unlawful act. One of the cases examined by the Supreme Court, the Senk K, was a case where, although the threats themselves were not in themselves unlawful, the background was unlawful behavior. So there was unlawful in the sense that there'd been a prior breach of contract. And so I sought to argue that Times Travel was a similar case, because the background was the breach of contract in not paying the accrued commission. And so the argument that I put forward was that in cases where the essential background is itself unlawful behavior of some sort, it really shouldn't matter whether it's part of the threat itself that is unlawful. What mattered was that all of the acts in question take place against the background and because of the initial unlawful behavior. So I don't read the Supreme Court as indicating that that third way isn't potentially open. And they certainly didn't, in my view, say that those cases had been wrongly decided. that's the Borelli and Ting case and the St. case. But I agree otherwise with everything Tom says about Ukraine. We were surprised at the end of the case that there wasn't more said either by Ukraine or that there wasn't judgment, some sort of analysis of the outcome Ukraine should be. But there it is. It remains to be seen.
Yeah, I imagine procedurally it must be pretty frustrating for them to have had written and oral submissions waiting for a judgment, then get stayed for this judgment, which really doesn't touch on duress. I mean, unlawful act duress very much at all. But
as it happens, I happen to bump into one of the Supreme Court justices who is sitting on Ukraine and Russia at the function last week, and I was obviously very careful not to say anything or to invite him to say anything that would embarrass either of us. But the impression I got is that he's simply waiting to be told at some point this case is coming back before you again.
Great. We're approaching 2, so if anybody has further questions, please do ask them now so I can get them in. Otherwise, I would put one more question to both of you, which is the judgment refers to the wider equitable doctrines of undue influence, of unconscionable bargains. Over my career, I've encountered various situations clients have found themselves in where, to me, it sounds like duress. So I think I recognise that. I have to say I have barely thought about undue influence or unconscionable bargains. Don't think I've ever played a claim on that basis. Don't think I've really put it with an ethical fraud claim. So as litigators, when we're looking at a duress type situation, and now knowing that whilst the Supreme Court hasn't closed the door or strictly delineated economic duress, they've given the basic message, it's going to be hard. What additional causes of actions or claims do you think that we should be looking at?
Well, on the facts of times travel, and where you've got, if you're dealing with a monopolist in any relevant market, then you should be looking at abuse of dominant position, because a dominant undertaking owes a special duty towards other players in the market. The trouble with such claims, and I'm not giving away any secrets, that abuse of dominant position was considered at once. The trouble with abuse of dominant position claims is that they are so expensive to mount. You have to obtain evidence from economists whose evidence doesn't come cheap. And those claims are notoriously costly to bring forward. But if you have got a situation where you can argue that the other party is dominant in a particular market, then that is certainly one claim to consider.
I think all I would add to that is, and it's not necessarily advice about what would have worked in this case. It'd be rather invidious if any of us were able to come up with a simple answer to that question from Philip's point of view. If only you'd thought of this, you'd have won. So I think we can safely take it that there is no such thing in this case, and that times travel got the best crack of the whip that it could get in this case. But I think what I would say as a general point, though, don't overlook the doctrines of the equitable doctrines, in particular undue influence. They can win cases. Of course, typically they are doctrines that arise in perhaps more domestic settings than this sort of largely commercial setting, but that's not a rule of law. And if you can be sufficiently inventive, then in a given set of facts, which may not simply involve the classic elderly lady who is persuaded to sign her entire fortune away to the person she met 3 months ago, which is the classic undue influence type situation, then it seems to me if you're sufficiently creative, there are circumstances where that can be done. It's one of the one of the oddities of our system, I think, of law, that even sort of well over 100 years after equity and law were fused, we still perhaps tend to think of ourselves sometimes as being on one side or other of the barrier between law and equity, and we shouldn't as lawyers. We should have all of those tools in the box ready to be grasped when the occasion demands it. So that may not be much comfort in situations like the ones in the Times Travel case, but I wouldn't encourage anyone to neglect undue influence as a doctrine.
Thank you. And I would just add that, factually speaking, I think a key focus is looking at what they call manoeuvring the claimant into a position of weakness. So you don't just have the dominant position and the threat, you have that something else, which is what I think that the Charterer did in Progress Bulk Carriers and led Cook to rule in that way.
Yeah, I think that was the problem in the present case, because in a sense, Times Travel had maneuvered themselves into a position of weakness by setting up a business which depended upon selling one product, which was only supplied by one airline with whom they had a very precarious relationship.
Yeah. We are almost at 2 o'clock, so I think we should end here. So thank you very much to Philip, to Thomas, to Leanne and the team at Hare Court, and thank you very much, everybody, for listening in. Goodbye.